thank you to everyone for making the time to join today's webinar, and that we're doing alongside Jonathan Strassberg from True Course Law and Raul Argudin from the Broadway League, who's also an independent consultant. So you'll be able to contact both Jonathan and Raul at the end of the webinar if you have any further follow-up questions. Raul right now is dealing with a couple of high priority issues within his own company, so he might be a couple of minutes late. So we'll get started and then we'll catch Raul up once he's joined. So the purpose of today's webinar is to really try and give you some advice and some guidance on the changing landscape in the US at the moment. It's mainly around the response and the reactions with COVID-19, which we're all being impacted with right now, obviously in different ways, and different countries are responding in different ways. So we're going to be mainly covering that. We'll be talking a bit about remote working. Obviously, we've seen a huge rise in remote working, so we're talking about some of the implications of that. The federal bill that's been released, which is the Families First Coronavirus Response Act, as well as the state, New York State program bill, and then talking about a few of the other reactions other states have had and what implications that has on the US workforce. So if I could just ask everyone, on your screen at the top right, you will see something that says gallery view or speaker view. If you click on gallery view, you will be able to see everyone, all the panelists' screens, rather than just the person that's speaking. So if you want to click on that, we will basically make a start from here. So without further ado, my name is Jeremy Wast. I'm the Chief Commercial Officer at PGC. That means I'm leading all of the commercial efforts. That's really kind of bringing on new clients, seeing the growth of clients, making sure that we're identifying new growth areas, whether it's from new clients or existing clients, and then working with clients mainly from the UK, also in the US, and the rest of the world. And I work alongside Catriona. Catriona, if you want to do a quick intro as well.
Yeah, hi everyone. My name is Catriona. I work alongside Jeremy, as he said, and I'm the VP of Strategic Growth at PGC. I'm based in our New York office. So typically once a client comes on, I'll work with them to help them realize their growth potential in the US, whether that's expanding into new verticals, looking at new states and expanding the business, and just really helping to help them with that. Also, there's also a Q&A option here, just to touch on that. So if you have any questions, please type them in. We will do our best during the webinar to answer them. Anything that we cannot answer, if we don't know or we don't get time, we will follow up. So please feel free to put them in there.
Great.
I'm Jonathan Strassberg. I'm a U.S. attorney at law as well as an English solicitor. And I have a practice helping UK and European SMEs, small to medium-sized enterprises that want to trade with or expand to the United States. I pretty much handle everything from incorporation through commercial contracts, and in many respects end up becoming an in-house lawyer for my clients' US interests. So of course this is of great interest to my clients and lots of other people who A, try to understand what's happening in the United States, and B, try to make that legal cultural leap between the UK and the US to understand these laws.
Great, thank you. And everyone, this is Raul. Raul, I was just explaining to everyone, you're probably saving the world at the moment back in the Broadway League. If you just want to give everyone a quick intro on yourself and also a bit about the company you work for. And I know you're obviously doing some independent work as well, so maybe a bit about that.
Good morning, everyone. I'm Raul Argudin, and as Jeremy said, I am currently working with the Broadway League, which is the trade association that represents all theater owners, all producers and presenters that have a show on Broadway or are touring with a Broadway show that is what's commonly referred to as an equity production, but it really means that it's a unionized production. What I do for them is I handle the HR issues that they have. Most of these, Broadway's a big place full of very, very small employers, and I help them with their HR issues and regulatory compliance. So my job is to have my finger on the pulse of what's happening in the world, that as far as the laws are and how they piggyback onto the collective bargaining agreements that we have. We have 14 collective bargaining agreements, and we work with 16 unions representing the managers, theater owners, and producers. Before that, and currently with individual clients, I help them with these same topics, helping small to medium-sized company mitigate any of the exposure that they might have because they don't understand how the law applies to them. And before then, when God was in diapers, I worked for Bloomingdale's for 17 years as a director of human resources, and my last stint was 10 years at 59th Street, which is a city unto itself with 2,400 employees. And if you haven't been to New York, it takes a city block in the city. And as somebody once referred to, one of our former general managers, getting anything done at 59th Street is like turning the Titanic in a swimming pool. And that is what it feels like at times, but I love what I do, and it helps me, and hopefully will help you understand what's going on at this time with laws coming in faster than we can even begin to understand them fully.
Awesome, thank you. Well, just obviously, as Jeremy said, there are a lot of changes happening. We've had the federal do a really strong response with the Family First Corona Response Act. New York have implemented their own act, and we're seeing other states provide guidance and clarification around paid sick leave, FMLA. And as of today, we actually have over 20 different issues of stay at home, shelter in place, closing non-essential businesses, all being referred to in different ways, but kind of meaning the same thing, that a lot of people are being asked to work from home. At PGC, obviously, we ourselves internally, we've been working remotely for nearly 2 weeks now. We actually implemented our work from home policy ahead of it being mandated. So thankfully, we've been able to kind of hit the ground running with that. And we haven't seen any cases of corona. So I think for us, our impact has just been on trying to work with our team and make sure we work fluidly, and then supporting our clients with their workforce across the different states. Would love to hear from Jonathan and Raul. What have you guys seen in your workplace? Have you seen any impacts either in your own internal organization or in the clients that you work with?
Raul, would you like to go first, or shall I? Well, I'm in touch with a number. My practice is a niche practice where I'm helping UK and European companies doing business in the United States. But for my colleagues, certainly my colleagues in litigation, you can't go to court. For many of them, that's been closed. And my colleagues in property sales and management, that's really come to a screeching halt. I think for all law firms, their business is dictated by the business of their clients. And so certainly speaking for my own, and I have clients from absolutely every sector, things have really been put on hold. I have clients, obviously any clients where face-to-face or in situ, on-site work is required, that's come to a screeching halt. I have other clients involved with software. Now the IT people are doing well in this. Anybody who can be supportive of remote working is doing very, very well. So software developers, software maintenance people are doing very, very well, but in-person work is suffering. Raul, what do you see?
Well, what I'm seeing is slightly even more severe because our industry is shut down. And New York shut down, Broadway shut down about 10 days ago. And shortly thereafter, all the road shows began to shut down because they were encountering city by city issues and being able to perform. Some cities were going to allow them, and some cities had shut down the venues. So by Sunday, really by Monday, every road show had closed down. So we are really dealing with the employers to try to understand what and help them understand what their employees are entitled to and how to go about it. And even those answers aren't complete because, as you saw, I sent last night, they finally published the 2 links on how to file for certain things that we don't even have how to file for everything that they're saying is available. So it is a continually evolving hunt and peck, really, to try to provide people with the information that they need to try to get the resources and that are available to them, financial resources, because that's really what everybody from my end is interested in. How do we pay our employees?
And Raul, the workers that were with these various shows within the Broadway League, have people been able to work at home? And if not, what's happened to those workers?
Some of the production companies and theater owners have staff that can work from home to continue this conversation. Some union officials can work from home, obviously, continuing the negotiation. The performers, the stagehands, the ticket takers, the box office, all of the other things besides what you see on stage, but everybody else, which is even more than what you normally see on a stage that gets the show to work, cannot work from home because they have no work. Their industries are shut down. In some cases, the show has not, 2 shows have officially posted closings. And there were shows that were either in previews or about to give their or in their first performances. And the reason shows are not shutting down and that a lot of businesses don't want to shut down, because if you have business interruption and you shut down, you lose access to that money immediately. So there's every effort being made to try to be able to get the show back up and running when we open in order to be able to have a business interruption case. And those folks are either collecting unemployment or if they're active, which the majority of them are not, trying to file for any of the relief that they may have coming. And some of them may be able to file for partial relief, but once you're officially laid off or a show has closed, you just become part of the unemployment pool.
Okay, understood. Now, fortunately, I mean, just to make sure everyone is aware, but the business model that PGC runs is we're employing workers on behalf of our companies. Fortunately, the industries that our clients operate within allow most, if not all, workers to work from home, which is a fortunate position for, you know, the workers to be in our clients and of course the PGC. I wanted to just pose the question to you both. When workers are being switched from non-home working or non-remote working, so from an office environment to now having to work at home, what should employers be aware of? So I'm talking here in 2 situations. One is a company that's, you know, managing their internal workforce, and perhaps also companies that engage with W-2 contractors. When switching these workers, or when I say W-2 contractors, W-2 employees on an hourly rate with a kind of defined end date, how should these 2 situations be managed when switching someone from an office to a home location, and what are the kind of implications?
So if I may on that, just be aware that the employment relationship doesn't change. You have the same rights and responsibilities between an employer and an employee. The challenge becomes transplanting some of those rights and responsibilities from an office environment to a home environment. Now, what we're probably most concerned with are making sure that the employer stays on the right side of the law when they transplant some of those rights. But also, there are going to be administrative issues that can either really dog an employer or make his or her life easier. And Raul, you and I can start talking about some of the legal and administrative implications. The first thing I would say, though, and I think this needs to be said, is this is such a dynamic situation. Things are changing all the time. We're all hearing lots of different information. And on top of this, or underlaying all this, are lives and families and children. So we need to be tolerant. We need to take breath. We need to make sure that at any given time, the last word has not been spoken. So patience is really key. In terms of legal issues, there are just a small handful of legal issues we have to think about when transplanting the employment relationship from the office to the home. And in no particular order, one of them is workers' compensation insurance. You're all familiar with that. Employers have a duty to provide workers' compensation insurance. It'd be a really good idea if they made sure they checked with their brokers or their carriers that insurance it will be covered for employees working at home, because the duty will still remain. There may be issues for some renters, for people who rent their property, employees who rent their property, as to whether or not they're permitted to work from home or they're covered. They should probably look at that. But workers' compensation insurance is something that has to be verified.
And just on that one, Jonathan, what about the health and safety responsibilities of the employer to ensure the workplace is safe as well?
I was just going to get onto that. So OSHA, occupational safety and health, that applies. And employers have to provide a safe environment, a safe place for their workers, and that can extend to the home. And there have been cases where it's held that it does extend to the home. So really the best thing an employer can do is ask an employee ask all employees to provide their own risk assessment of the workspace. Now, it would be great if an employee could look at their home and decide where they're going to work and make that one spot their spot for working. Now, that's for a number of reasons, because we're going to come into issues of confidentiality. We're going to come into all sorts of other issues, data protection, as well as health and safety. There are all sorts of online at-home risk assessment forms. If you really just Google at-home risk assessment for safety, you'll find a number of them. If you can have your employees fill those out, neutralize any hazards, which most typically are going to be electrical wires, things like that. That would be helpful. If they want to take a photo of their workspace, send that in. That would be helpful as well. We take care of that. Moving on from there, the employer's obligation to provide some disability accommodation to their employees at their workstation is probably transferable to the home, is transferable to the home. So if somebody's suffering from carpal tunnel syndrome and they have certain accessories, the employer would like to try to provide those accessories to the employee at home, or certainly inquire about it. And the big thing here is the employer.
Just in terms of that, I've seen like a number of organizations just providing a budget so that an employee can buy what they need in order to make their workspace comfortable. Is that sufficient?
I think that in the end, if an employer can document that they've made a good faith effort to assist the employee in obtaining whatever they need to obtain or obtain it for the employee, then that I would imagine that would be sufficient. What you want to make sure of is that you've made a good faith effort. This truly is a situation where people will need to pull together. So it's not a situation where an employee is sitting at their desk at their office and an ergonomic accessory has to all of a sudden appear. It may be that the employee and the employer have to work together on this in order to obtain.
And I think that's kind of what we talked about yesterday when we caught up. It's like documenting everything that you've done over the next few weeks so that you can show evidence of, your efforts and what you've tried to do. Ideally,
this would all be in some sort of agreement signed between the employer and the employee. And by the way, not a harsh legalese agreement, a very friendly, working together, cooperative, plain English kind of documentation of what everybody's doing to pull together and make this work. Obviously, here the employer has to be the first party to lead this. But that's not the end of it. You have disability accommodation. You want to make sure, this is a couple things that are very important here. You want to make sure that, some employers are going to work from home, some employers are not going to work from home. I highly recommend that every employer take a few minutes and sit down and write what is the difference between the job responsibilities of somebody who works from home versus those that work in the office. Because you need to make sure that if you are going to treat them differently, you treat them, in other words, send some home and keep some in the office, that there's a really legitimate business purpose for discriminating between these two types of employees. Now, obviously, the rule is non-essential for a lot of places, non-essential employees have to stay home. That's a form of discrimination, but it's legal discrimination because it's not based on a protected category like race, religion, national origin, or anything like that. So you want to really document that if you're sending people home, you're sending them home for a legitimate business purpose. If you can take some time and just outline that on a piece of paper, you would like to show it to your employees as well. That would go a long way to make sure that nobody can later claim that you've violated the law. And the last point, there's meal and rest breaks. If people have a right to meal and rest breaks in the office, they should have them at home. That's not too much rocket science, but the more important thing here is a lot of people are going to get sent home. Some of those people are going to be governed by the Fair Labor Standards Act, and some of them aren't. Now, the Fair Labor Standards Act is a federal law designed to protect people who have your ordinary staff worker. Generally, the people who earn less than about 36,000 pounds a year. 35,568 actually is the number. That's $684 a week, not pounds, dollars, forgive me. Now, for those people, you need to make sure you put something in place, because for employees who are not exempt under the Fair Labor Standards Act, if they work more than 40 hours a week, whether it's at home or in the office, they have to get paid time and a half for every hour over 40 hours a week. So you need to construct a timekeeping mechanism at home.
Yeah.
And here's the situation that you need to avoid. You need to avoid an employee who works 45, 50 hours a week for 5 weeks, doesn't record it, and then comes back later and says you owe them lots of money.
Awesome. And I think Jonathan actually wrote a really good article about working from home, outlining these different considerations. So what we can do is we can also send that to everyone that was registered, so they can actually look into that and have that written copy of kind of like a nice checklist.
Oh, yeah, okay.
To do. I think that would be really helpful.
So
there's one thing
Raul,
to add to working from home is that a lot of the considerations that Jonathan outlined correctly also may change state to state. OSHA has requirements state to state. They will probably never inspect your home for safety, but it's still a responsibility to make sure that it is a safe place. The people that are overtime exempt and are salaried, the rates change in some states. In New York, it is considerably higher than what the rate is federally. The guidelines are very much the same, but just be aware and be conscious of where you are and make sure you're consulting with somebody that can guide you for what any exceptions might exist in the state that you are working in.
Got it.
Very true.
Okay.
That's very true.
Thank you, guys. So I think for us, as I was saying, majority of our workforce has moved remotely. We've done exactly what you guys have mentioned. We have remote working policies, ensuring that the burden of proof is also on the worker to demonstrate if there is an issue with hours, in terms of perhaps the employer is disagreeing with how many hours the worker has actually done. The worker really needs to demonstrate that they have done that particular work. And obviously, Jonathan, the best route really would be to use some kind of timesheet system to track that historically.
Can I just mention one or two other more administrative things which could have legal implications down the road you really have to think about? Now, some remote workers, people you send home, are going to work on computers provided by their employers. That's wonderful because they have antivirus and data protection, security programs provided by the employers. Some of them might work on their own computers, in which case they might be integrating company information with personal information. Now, here's where you want to be careful, because you might have confidentiality issues. So if you are a company who's dealing with your client's confidential information, and then you compromise that confidential information because it's placed onto an employee's personal computer at home, which is opened up in the kitchen rather than at the workstation, somewhere off to the side. These are things that have to be discussed. It's discussed in the memorandum that I wrote that Catriona will set up, but please pay attention to that.
Great. Thank you, Jonathan. Thank you, Raul, for your thoughts on remote working. So we're going to kind of move on to the main topic here, which is the US government's response to the coronavirus and the impact that it's having on the economy. So there's two main items that we're going to discuss. The first is the Families First Coronavirus Response Act. The second will be the New York State Program Bill. On the first one, because a lot of the clients or companies on the webinar right now utilize W-2 hourly employees, and they're also going to be concerned about their own internal workforce. When we go through any responses that you give, can you just clarify whether you're talking about internal salaried workers or whether we're talking about hourly W-2 employees that are working on a different site, mainly because these companies are recruitment agencies? So that there's two kind of scenarios in which we'll be kind of talking about. So Jonathan, Raul, would one of you want to just, I guess, give a bit of a summary on the Families First Coronavirus Response Act, a little bit about why this bill was brought forward, and what it's supposed to be doing, firstly?
Raul?
Do it. Why it was brought forward? Because we needed it, because we had no protections for salary continuation of any sort when people were asked to stay home. And what it does is really three things. It amends the Family Leave Act law and takes it from unpaid to paid for 10 out of the 12 weeks. It changes the qualifying requirements from having worked a year and 1,250 hours to only 30 days. And it provides payment with limitations to workers who are taking time off to care for, in this particular case, for themselves or for a dependent child, if the child is either ill or if they are their school or their place of care is closed down. And that's a very high level. That's not the nitty gritty of it. The second part of it is it provides for 14 days of the paid sick leave part applies for 14 days. If you are quarantined or isolated or your child's school is closed down, for you to take care of that during the first 14 days. Once the 14 days are over, you go into FMLA. The first 2 weeks are not paid, but you can substitute those 2 weeks if you have paid time off remaining from your employer. And the third part that it provides, it's tax relief. And what it says is, if you are paying people FMLA, which you are responsible for that payroll, then you would be able to take a tax credit on your payroll taxes, on the portion that every employer pays for payroll taxes, to mitigate some of the expense that paying this out will do.
Raul,
yes.
Oh, I'm sorry. The paid sick leave portion, that's 80 hours of paid sick leave. So is that 10 days? And how does that work? Because you'd mentioned 14.
Because I mixed them up with what the New York State does, and it winds up doing the same thing.
Absolutely.
2 weeks working days, so 10 days.
Working days generally, or the average that somebody has worked if they're part-time over the preceding 6 months, I believe is the statute. And again, I'm not getting into nitty-gritty because I have reference paperwork that I have next to me, but I need to look at it every time I speak of it because it is new and the information is similar, but not exactly the same. And I'm covered by two in the state that I'm in, something that many of you may or may not, depending if your state has done something. Many states have, many states have not. So you need to figure out what applies depending on your locale.
If I can make a suggestion at this point, just an observation or now, the New York law, it would be a little bit of a misnomer to say that the New York law is in addition to the US law, to the federal law. Because to say that would sound like you get 10 days of paid sick leave under federal law, and then you get another 14 days of paid sick leave under state law. That's not the way it works. The state law only pays you to the extent that it is in excess of the federal law. So you don't get a double payment. You simply get an extra payment. Do you understand the difference?
Yeah.
Yeah.
Okay. So we need to understand the federal law first, and then we see where the state law augments that.
Yeah, so the federal law is the baseline, and then anything that is
Correct.
above beyond that, as per the state, would add on to that, but not in terms of the whole duplicating it. So I think
that's correct. That's correct.
In terms of the Family First Corona Response Act, like obviously, you know, it's got the paid sick leave that people are eligible for. Can you guys just provide a little clarification of how would an employee actually become eligible for that paid sick leave? What are the requirements around that?
Right.
Jonathan, just before you jump in, I just want to make everyone aware that you know, these bills were passed very quickly because they were essentially in response to an emergency. So there is guidance notes coming out, and it means that what we're talking about, there are still things open to interpretation. So we just encourage anyone before making any decisions to seek, you know, legal advice. And the way that you interpret things must be your own interpretation alongside legal counsel. So just to clarify that before we jump in.
I was on the phone last night with across the pond with a New York lawyer, grappling with a lawyer based in New York, grappling with the same thing, and rather pulling her hair out over the way this New York law was written. And you know, the response has been swift. It's been wonderful, but it's really quite coarse. It's not fine grained, and that's going to have to follow. So again, that's why we're all going to have to be a wee bit patient. Now, prior to this time, and Raul, correct me if I'm wrong, prior to this time, there's never been a federal right to paid sick leave for employees of private employers. Isn't that correct?
That is absolutely correct.
So one of the remarkable things this is, and especially given the political climate in America, is that at least for this very brief period, it establishes a federal right to paid sick leave for employees of private employers. And that's rather monumental. And what it provides is 80 hours. Now the US work week is 40 hours a week. So 80 hours of sick leave for full-time employees, and then a pro rata number of hours for part-time employees. If the employee, now there are 5 qualifications, 5 separate qualifications. And the first 2, well, we'll do them as we go. The employee is subject to a federal, state, or local quarantine isolation order. On that basis, they can get paid sick leave. Secondly, the employer is experiencing symptoms of coronavirus and seeking a medical diagnosis. You can't simply say that you have symptoms. You have to be seeking a diagnosis. The employee is caring for an individual who is quarantined or self-isolating because of corona. Again, that's because of corona, not because of some other disease. These laws are specific to coronavirus. Fourth, the employee is caring for a child whose school or place of care has been closed. Or lastly, the employee is experiencing substantially similar condition, physical ailments specified by the Secretary of Health and Human Services. So on those bases, the employee can take sick leave and get paid. Now, my understanding is that they can get paid from the first day they leave work. Unlike the FMLA, the first 10 days are unpaid, but here you get paid immediately upon leaving work. Is that right, Paul?
That is correct. And the intent was to cover people if they were under the 2-week quarantine, which is the guideline that's been thrown around out there from the CDC and from everybody else, to self-quarantine or isolate, depending on what's going on, for the initial 2 weeks after exposure or being diagnosed with it.
Right. An important point to remember is the people who can seek sick leave payments are people who are either seeking payment because they're ill themselves or seeking payment because they're caring for somebody else. And that's an important distinction because the amount they get paid changes. So if they're an employee who are themselves subject to a quarantine order or they're experiencing symptoms, they get paid caps out at $511 a day for an aggregate of $5,110. On the other hand, if they're taking sick leave because they have to care for a child or because they're experiencing some other symptoms, then their payment caps out at $200 a day, not $511, and they have an aggregate of $2,000. So there's a difference there.
Interesting. So for people on the webinar right now, in terms of them trying to manage this internally in their own businesses for their own internal workforce, is there anything that they can be doing now to try and prepare for this? Do they need documentation? Do they need to be, getting doctor's notes? What are the practical steps that people might think about for their internal workforce to manage the federal bill?
I think it would be a really good idea to diarize the information they receive each day and the actions that they're taking. And when they diarize them, keep them limited to coronavirus issues and legitimate business decisions being made in response to those issues. There's one thing I want to say about the sick leave. The people who get paid less, the $200 a day, those are people who are caring for family members generally who might be ill. The whole idea of that is to fill in for the family and medical leave that the federal law that pays you for family medical leave is restricted to caring for children. This fills that in for caring for other family members, if you understand. So you can go ahead and do that. It kind of fills in the gap a little bit conceptually. So just so the viewers
that
can.
Makes sense. Yeah.
Okay.
And then in terms of eligibility, like one question we have got, and I think is probably a good one to kind of keep front of mind and answer throughout if we can. Obviously, this relates to W-2 employees. For people that are being employed as a 1099 or you're working with a corp to corp or those sort of different types of agreement, does this apply? Is there any sort of support for them, or are these just specifically for W-2 employees?
These apply to employees, not to independent contractors.
The only way that it would apply to an independent contractor is if that independent contractor, when they formed their LLC, got workers' compensation insurance, which probably would have been smart to do. And the second part, if they would have gotten paid family leave insurance. Paid family leave will entitle you to some pay, especially in New York, but it is an individual policy that you must get from an insurance carrier. I know that most individual practitioners, and we deal with actors who incorporate themselves in order to be able to take advantage of the taxes and deduct their expenses, but they don't get paid family leave. So when it comes time to take the time off, the employer may grant them the time off, but the employer is under no obligation to pay them because the individual is not the employee, the corporation is the employee, and it's their employer that has to pay them. So that's the only tricky part with paid family leave in New York. That has been only a law that applies to New York state residents. If you're under the federal, I believe that the new bill, the scraps that I've gotten from what was passed yesterday is that it addresses some of the needs of this gig economy, but especially for unemployment. I don't know the details, but the bill, the Family First, does not take into consideration those 1099 employees.
That's correct.
Sorry, I was going to, Jonathan, go for it.
No, the only other thing I was going to say was some of your clients, some of the people watching this, might be sending independent contractors to work with their clients. Now, there is a funny wrinkle for a lot of states where they want independent contractors to be covered by workers' compensation. Now, to the average lawyer, that is a contradiction in terms, because workers' compensation, we always think of only applying to employees who get a wage. And I don't want to get into it too much, but it has everything to do with the area of misclassification of employees, contractors who really should rightfully be considered employees and pay state income tax. States can have different criteria for determining who should be an employee. They can have different criteria from the federal government. And based upon those different criteria, they can require independent contractors to have workers' compensation insurance. So this is a slightly marginal issue, but if you happen to be one of those companies that's sending independent contractors, call your insurance carrier and ask them about this and ask them how to address it for workers' compensation. Yeah.
While we're actually on this particular topic, just briefly to touch on, I think what's perhaps you guys have seen similar, but what's been exposed more than ever in this is how workers operating as 1099s and sometimes corp to corp are actually left out and unprotected. Do you think that this is going to change going forward? Like, do you think that there might be a potential category of worker that, you know, is not a 1099 or even some kind of portable benefits for workers in this way? Do you think this has been really brought to light?
May I?
Yeah, go for it.
What I would say is, first, I wouldn't get overly thrilled of how generous this law is. There are a huge number of employees that are not covered by this law. So this law, something we haven't talked about, are the exceptions for employees with less than 50 employers, for employers with less than 50 employees. And that's possibly the vast number of employers in America and vast number of employers anywhere. Now, let's look at that. Employers with less than 50 employees, the law splits them into two groups. Employers with less than 50 down to 26 employees, and then employers with 25 or less employees. Employers with 25 or less employees can actually get out from having to pay this due to hardship. Now I'm going to have to look in my ever-changing little act for this. Raul, can you fill that in while I'm looking for this?
About what's a hardship, or the people?
What's a hardship, yes.
The way that it's worded, and I'm doing this off the top of my head, is for employers whose viability comes in jeopardy from paying these things. How you get the exception is one of the things that we're still waiting for directions on how to file for those exceptions from the Department of Labor, because they need to approve that you're one of the hardships. And what are they seeking in order to give you that exemption?
That's correct. So that's a huge number of employees. In addition, it doesn't cover employers with more than 500 employees. And that's all the Walmarts, the Targets, all the large, Amazon, all the large employers. So really, the number of employees it covers is not that great. So when we talk about whether there will be something for the gig workers, for the independent contractors, they just came out with another law. Congress just passed another law, which is far more generous. I don't know whether that has anything for independent contractors in it. I don't think it does. If it's like the UK, independent contractors will be the last ones to be cared for.
Got it. We've got a question that's come through. I just want to respond to that. The question was kind of in reference back to PGC here, but also what you were just talking about, Jonathan, in terms of exemptions for certain employers, because on the other end of the spectrum to what you were saying, any employers on the federal bill, any employers with over 500 employees are exempt from the FFCRA. So the question that was asked, PGC as an employer is exempt from that. So the answer would be no to that one.
And another question that we got in as well was, is the count of the workforce for the US workforce, or if you are a global organization and you have multiple workers across multiple countries, is that taken into consideration? I assume it's just your US workforce.
The original Family with Medical Leave Act applied to employers of more than 50 employees within a 75-mile radius. The mile radius has been removed.
Okay.
So that's important to remember. It's no longer, so I would say you probably have to count all your employees.
Across globally.
This is not legal advice.
That's your interpretation. Okay.
That's my immediate, well, I think what we're talking about here, we're almost giving our impressions.
Yeah, that's really helpful though to know that that mile radius has been removed. So probably something, if you're looking at that, to go get legal advice and then make your decision based on your interpretation of it.
Yes.
Yeah, and just the person's come back and just said, sorry, I didn't understand the answer. Jonathan, I'll respond back and then let me know if I'm off or on course. But basically, the rule used to be under 50 employees within a 75-mile radius. That's now been
over 50 employees.
Over 50 employees, 75-mile radius. That's now been removed. So essentially, what that could be interpreted as, if you have over 50 employees in the US or globally, you have over 50 employees.
Over 50 employees and less than 500.
Yes, then you would be caught within that.
Well, if that's your conclusion, then I think you have to go get legal advice.
Yes.
So I think that if you are within that, then you need to have your organization looked at with greater scrutiny to understand what you have to do.
Great.
And this is the sort of thing that we haven't found any guidance on yet. So it's probably also the sort of thing where you want to err on the side of caution. There are going to be a number of business judgments that have to be made in how to respond to these laws. And I think erring on the side of caution would be prudent at this point. Yeah.
Got it. I think now's probably a good time to move over towards the New York State legislation.
Can I just ask one question about the paid sick leave? Just for if a worker already has paid sick leave that they have accrued, and the federal government is now offering these 14 days for coronavirus related.
State government 14 days, federal government.
Apologies, yeah, federal. Does that go in addition to their paid sick leave?
If you're talking about like New York has earned safe and sick time, and you had 5 days, I think was what you were entitled to. The employer cannot force you to use the time that you had accrued prior to these statutes. Those can remain for later because the federal statutes does not only is in effect until December 31st and does not carry over to the following year and is not paid out either. So what you have in New York, any paid time that your employer gave you prior to all of this, you can use if you want to, and you can use it to cover if you're going on family leave to cover your pay for the first 2 weeks. You can use your sick time, you can use vacation or any sort of flex time or paid time off that your employer is giving you. You cannot be forced to use it before you dip into this new bucket.
Same goes for the federal.
Right.
Federal grant. It is an employer cannot stop you from using your accrued paid sick leave.
Perfect. That's great.
Cannot require you to use it either. So it's both ways.
Yeah, it cannot require you. Yes.
The employee gets to decide how they want to use that time and when, as they would have in the past as a regular employee.
So, for instance, just to make it clear, let's say that an employee is in New York is given 14 days of paid sick leave. 10 of those days come from the federal rule. 4 of those days come from the extra provided by New York. And then if under their contract of employment or under city law or whatever, they've accrued 3 more days, they get those as well for a total of 17.
And of course, if someone is working for an employer that's exempt from the federal law but caught within the New York state law, then they would get the full 14 days from the state law.
That's correct.
Basically, yeah. Okay, great. Raul, would you mind perhaps just giving a summary on because this has probably affected you guys more so as well, on the New York State program bill, and maybe just give a bit of thought about why that was brought in when we've just had this federal bill come in, and why is New York State the only one that's brought this, and are we thinking that other states might follow suit?
I don't know if other states will follow suit, but I think that it was brought in because Governor Cuomo did not want to wait for the federal government to take action. And it seemed like the federal government was not taking action in many ways, and he wanted to make sure that New Yorkers were being protected. The New York State has a criteria that varies from employer by employer side. So if you have less than 10 employers and less than $1 million in income, your 5 days of sick leave are unpaid. If you are an employer with 10 or fewer employers, but greater than $1 million, then you would receive 5 days of paid sick leave, followed by the eligibility for paid family leave or temporary disability benefits. New York State is one of the few states that has mandatory disability benefits. The disability benefits max out at $170, I believe is the number per week. So it's not much money, but it allows you to supplement your income. They're allowing you to double dip, which normally they don't, in order to be able to get the maximum benefit that you can get. And employers with over the employers with a net income of $1 million and less than 10 employees, or employers between 11 and 99 are all in the same bucket. 5 days of paid sick leave, followed by eligibility for paid family leave and temporary disability benefits. And employees more than 100 or more employees, as well as public employees, would receive the maximum 14 days of paid sick leave. No cap on the size of the company. So you just need to be an employer in the state of New York. So that's one of the differences. Disability still just covers your own personal disability. You cannot file for disability benefits because you're caring for somebody else. And then the paid family leave benefits supplement the temporary disability benefits, and you can earn up to $150,000 annually. The cap is, it does not cover any income over $150,000.
Got it.
And then and that's again very abridged, and I can send documents to you that I put to summarize all of these, or I think I may have sent them already, that you feel free to share if you'd like to. And then paid family leave, which is taken by the employee when they are unable to work due to a mandatory or precautionary isolation order by the State Department of Health or local board of health or any government entity, or to provide care for a minor dependent child of the employee who is subject to a mandatory or precautionary isolation, or they're not in school because they can't get to school. An employee may collect any benefits that would exceed $840 in paid family leave, up to $2,043.92. That's the maximum that you can collect on a weekly basis. So it's considerably more generous than some of the others if you're in New York State. That's the helicopter ride on paid family leave in New York.
Great.
Well, there are one of the acts has restoration provisions. Am I correct about that? If somebody goes off on paid sick leave the employer, if the position is still available, has to take them back after paid
Yeah,
sick?
the employers have, if you close your place of employment, which will not involve a lot of your benefits, or if you eliminate the job while this is going on, the employer needs to make a goodwill effort to either find another position that the person could do. That's kind of hard in this environment when everybody is cutting. I doubt that there's another position that they can currently do, or have a goodwill effort to call back that employee for the next 12 months if the job or a similar or a comparable job that the employee would be qualified for becomes available.
Now, is that under New York or is that the federal law? Do you know? I can't remember at the moment.
I remember it at the moment,
have
but
it
I'm looking
here.
at my notes to see if I put it, because the fact that I remembered that means that it's somewhere.
Yeah, I have it somewhere as well.
I
I'm not-
don't remember.
It's the federal law.
It's the federal law that.
It's the federal law, yeah. And I was thinking about this because I had a number of questions from people. Can I terminate my employee now? Now,
Yeah.
first of all, I would be really, really hesitant to terminate an employee while they're obtaining federal or state benefits, family leave or sick leave benefits. Can I terminate my employee before they start receiving those benefits? And here's the rub. You terminate an employee before they start receiving benefits, saying the position's no longer available. And then as soon as the business becomes viable again, they have to hire somebody. The employer might find themselves between a rock and a hard place because they have to rehire that same person. And in rehiring that same person might be an admission that they didn't have to fire them in the first place on some level. It's just a very, very scary thing. You need to pay them their benefits.
My advice to anyone is, do not terminate anyone simply because you want to use this as an opportunity to clean house. If you have a legitimate track record that you have been on the path to firing this person for performance issues, you may want to pursue that, but I would have somebody help you review what you have, because you're going to need to substantiate that, because I doubt anybody's going to go away quietly in the dark of the night in these financial times when there's no other job coming, unless you have a very strong record that this is where you are going to land now.
Right.
And the people are not going to be there.
Right. And the presumption is going to be that you want to terminate these people because you didn't want to pay them these benefits. And for those people for whom there's a right to restoration, those people are going to be on your doorstep, and they're going to be demanding explanations to why they never got their benefits paid. It's a different thing to fire them after all benefits have been paid. Even then, you need to document the reasons why.
Yeah.
And of course, there can be legitimate business reasons.
And quick question. I may or may not know the answer to this. Now, let's say if a business was expecting a slowdown because of coronavirus and they temporarily laid off workers, I believe it's furloughed the workers, while they are temporarily not working for the client. Let's say they develop symptoms or get a confirmed case of coronavirus. Are they still eligible for 14 days paid sick leave or not?
Well, furloughed is a very specific status, which means that you are on hiatus from the work and you're still an employee. So it could be argued that as an employee who will not need to do new hire paperwork, use that as your guideline, when they return to work, they're probably entitled to those benefits if they qualify. If they have been laid off, it means that there is a separation of employment. If they have been terminated, it is a separation of employment. If you went out of business, it would be the same thing. They're no longer your employee. On a furloughed employee, you're just saying to the employee, we're going to press the pause button for a determined or undetermined amount of time, but they're still your employee, and you're saying to them, we're going to bring you back to work. We just need to press pause on the play button.
Yes. Okay.
I think that's right.
Got it. It makes sense. It makes sense. Now, let me ask you another question. If the worker was unable to work remotely, and right now there's a stay-at-home order, and they're to stay at home, what happens in that situation? Can they seek unemployment insurance? Are they able to get paid sick leave? Is it paid family leave? What is the employee going through at that point?
It seems to me that if they're unable, okay, so I think I had written something to you about this earlier. Yeah. And I think the best way to address this is to go down the path of chronology. So on day one, people are at work, there's no coronavirus, everything is fine, things are ticking along. Later on, coronavirus appears, some people become ill and they have to go home. They may or may not be granted paid sick leave by their employers. Later on, the government issues an order that all non-essential employees have to stay home. Of that group of non-essential employees, some will be able to work from home and some won't. Of the ones that are able to work at home, or any of them, they'll divide up into three groups. Those who become ill, those who are able to work from home and do, and those who are not able to work at home and don't. So of the ones who are able to work at home and do, they're paid in accordance with their employment contracts. The ones who are unable to work at home because of illness should be getting sick leave. The ones who are unable to work at home because factual circumstances having nothing to do with coronavirus prevent them may well be constructively unemployed.
Yeah.
Raul, what would your interpretation be?
My interpretation would be similar to yours, that if you're talking about somebody that is unable to work physically, they're entitled to sick leave. It's somebody that is unable to work because their job is not performed at home, cannot be performed at home, then they would go on unemployment. Unemployment does not qualify if you're ill. Unemployment requires that you're ready, willing, and able to work. If you're not able to work for any reason, disability, otherwise engaged, a vacation, it disqualifies you from unemployment. But if you're ill, the benefits would kick in. If it's a matter that your job cannot be performed, then your job cannot be performed and the job doesn't exist, you become part of the unemployed pool.
Mm-hmm.
Understood.
Something I would say about this, and this is quite general in nature. There have been a lot of conversations about this, and people are using the word quarantine very, very loosely. And it's very important to keep the definition to hand. And the reason it's become confusing is we've had people come off cruise ships and have been physically segregated because they have been exposed to a contagious disease. That's a quarantine. When individuals or groups, specific individuals or specific groups of individuals are separated from the public because they have been exposed to a contagion and they pose a threat to the public. That's a quarantine. It's related to specific individuals. The state telling everybody to stay at home is not a quarantine. It's designed to protect the public. It uses restrictions on public movement in order to protect the public, but it's not directed to a specific group less than the whole. It's directed at the population as a whole. It's not a quarantine. So if your employees come to you and say, I'm subject to a quarantine order, so pay me, well, you're not subject to a quarantine order unless you fall within the definition of that. And that's not to answer whether or not these acts for wage payment will apply or not, but it is important to understand what is and is not a quarantine.
Got it. Thank you, Jonathan. It is really, really important that people almost scrutinize the bill themselves to try and figure out exactly what it means and really read each word carefully. There's a question here that I'm going to answer in just a second, but just to say that we're now at the 1 hour mark. We've made time to continue. So we're going to go through a couple more topics, but if you have questions, I would really encourage you to put the questions into the Q&A section at the bottom. We will answer the questions as we go through. If you've got particular scenarios with workers or clients, we'll do our best to give our guidance. Again, it's not legal advice, without further ado, I'll just quickly answer this question. So someone's asked, as a staffing company with contractors, and what they're referring to here, I presume, is W-2 hourly workers, should we expect to pass through the cost of paid sick leave through to our end client? My answer to that would be, traditionally, an end client is utilizing a staffing agency for a couple of reasons. One, of course, is to find suitable talent. Another reason is to have some kind of fixed cost that it's going to cost them to have this resource performing work for them. So typically, paid sick leave would be a cost to the agency of doing business, seeing as it's them or a partner that's engaging the employee. However, I think in these circumstances, it's really important to be having honest and frank conversations with your end clients about changes in law that affect you. Ideally, of course, you would pass that cost straight to the end client because they are the one receiving the benefit of the work being performed. If they're not willing to accept the full cost, then perhaps some agreement could be made. But it's really important first to check what contract you have in place with the client. We always encourage our clients to try and pass through these costs, but typically it's unlikely to. But it's usually good to check the contract first and then have a transparent conversation with the client. Jonathan, Raul, if you have anything to add to that as well.
I would say, life begins at the contract. So you need to review what the contract says. Frankly, what I would do is to first review what the contract says and really scrutinize what it says so that you understand so you have a reasonably educated and defensible understanding of what your rights and responsibilities are, as well as those of your client. And then approach your client, putting your best foot forward. Because this is going to end, this terrible situation is going to end, and you really want to keep good relationships with everybody along the way. You want to come out the other side as strong as you can be, with as many business opportunities as you can have. So understand legally what your rights are, so that when you compromise, both you and your client can have a clear understanding that the compromise is grounded in fact and in good faith.
Perfect. We've had a question come in just via the chat, different way. So I'm just going to answer that quickly. Somebody's just asking, in regards to working with PGC, how do you record if your employees are absent with issues related to COVID-19? We are currently reaching out to workers to touch base with them and let us know if anything comes up so that they can communicate that back with you. We would encourage all of our clients to do the same, just to chat with your workers, make sure that they're looping you in if there are any absences, and then reach out to us and we'll just help you navigate that on a case-by-case basis. I think we're just sort of taking everything case by case as it comes in, but if you have any questions around that, feel free to reach out to us and we can provide further guidance on how to kind of navigate that.
Right. The employer has the right to monitor the working time of their employees. So that includes both exempt and non-exempt employees, exempt and non-exempt under the FLSA. Most certainly they have to monitor working time of non-exempt employees for the purpose of paying them time and a half. And really any rational system that is completed by the employee is good. So as long as the employee records when they're working and when they're not, and provides that information to the employer at regular intervals, reasonably, ideally weekly.
Perfect. Another question for Raul and Jonathan here. If I need to cut costs, I have a team of healthy employees all working from home. None have coronavirus. If I were to terminate 30% of my team, what do I need to do differently than normal? They are all at will.
That's sort of a trick question. Because
someone's trying to catch you out.
That what you were doing before was really a good idea that protected you. So in the case that you had a system that you were fairly certain was not discriminatory and that was using standards that were fair, then you absolutely should continue to do it the same way. What it shouldn't be probably is something random. You want to be able to explain how you came to do it. Did you use strictly seniority? Did you use a combination of length of service, experience, and performance? But whatever method you are using, my counsel would be consistent, don't do it randomly, and don't do it based on who you thought was strictly a subjective good worker, bad worker criteria at times like this. Have a very formal, non-discriminatory process that is consistent throughout. Do you have anything different?
No, nothing different. I would say that you want to make sure that to the extent possible, that your decisions are based on quantitative measurements to the extent that you can, or as close to that as possible. So you write out your business operations, and then you decide which operations are essential or which operations are not essential. And you record it as that, and you document it as such. Now, along the way, you might also want to, prepare this report and run it by your accountant as well, to make sure that the accountant has something to say about your financial business plan to survive this period. The more that you can document in writing that your decisions are based on legitimate business purposes, the better. And again, like Raul said, you want to stay away from anything random. Randomness will never help you. You want to absolutely stay away from anything personal. Don't be talking about dismissing somebody because they're difficult to work with. You are talking about job roles and what's necessary to have the business survive these times.
And Jonathan or Raul, in this situation, when terminating an employee in the current climate, is it enough to give a very limited amount of information as to why that person or individual is being terminated, or is it better to perhaps have kind of an audit trail of why you're making that decision and present that information to the individuals?
I'm a firm believer that while you need to be careful on what you share and how you made that decision, and you don't need to go to the nitty gritty, you need to give some idea to the person as to how you've made the decisions, because failure to do so encourages people to make up their own reasons. And that's what gets you into trouble. So I think that saying our marketing is down and we made a decision to reduce the workforce based on this criteria, this ability to perform this task, whatever your criteria was, as Jonathan said, whatever your business case was, if it's an entire department, it's sometimes even easier, because at this point, if you have, for example, a marketing department, who are you marketing to? There's no customers for anything. So you've eliminated the marketing department and that's what you say, and it's even. But if you have a department like accounting, and maybe you had 10 accountants before, and now you only need 5. Well, how did you come to choose the 5? What are the qualities that you were looking for that somebody had or hadn't? What was the criteria? Why did you make that decision? And what was going on in the business that prompted this more specifically, if you can? Because again, when people don't have answers, they create their own answers. And those are usually personal and not professional.
All of that is 100% correct. And I would also like to add a different perspective. So we always think about these in prospectively, about what we're going to say and how we're going to present it. Let's look at it retrospectively. At some point, terminated employee who's disgruntled or feels that they may have been treated wrongfully is going to go to a lawyer and say, can I sue my former employer? And the lawyer is going to say, well, show me what documentation you have. What you want to make sure is that whatever papers and whatever documentation are presented to that lawyer, when the lawyer looks at it, he says, it's really not worth my time.
Yeah.
You don't have anything here. That's what you want. You want to make yourself an unattractive target. And the best way to do that is to put, you set a stage in documentation, the current status of the business. You don't have to disclose your financials, but you have to disclose how you're doing. Things are bad, they're bad in certain areas. We see the greatest challenges in these areas or those areas. We need to reduce our expenses. We can only reduce our expenses in these or those areas, and therefore we have to cut in the following areas, and blah, blah, blah. And it's all rational, it's all business related. You don't want, when you talk to the employee, you really don't want to be going beyond the terms of the documents you created. You would like to create documents which speak for themselves. And then when you speak to the employee, you limit yourself to the content of the documents. That's how you maintain consistency. And then when the employee goes to their lawyer, that consistency continues. And the employer doesn't find a reason to sue you.
That's some really good advice. Thank you both for that. Really good advice. Okay, another question. Within the supply chain, whose responsibility is it to determine whether contractors or W-2 employees are essential or non-essential?
Within the supply chain, that would be an organizational discussion of people who employ.
I think that the question means, let's say there's a recruitment agency, so there's a worker, there's an end client where the worker's working, and there's a recruitment agency. Whose responsibility is it to say whether the worker is essential or non-essential?
Or looking at their clients that they're being placed on.
Yeah, that's a really interesting question. And that's certainly a novel question. The way I would approach this would be the analysis should start with the entity that has the most to lose by continuing with the status quo. And that entity is likely the client, because the client has a contract to pay these employees. So the client has to prepare this coronavirus response, emergency response business plan, which is essentially what it is. Call it a coronavirus emergency response business plan, designed to get you over the next 12 months. Then shares that with the recruiter and move upstream. I would say that the whole response starts with the client and moves upstream, if that makes sense to you.
Yes, it does. It does.
Raul, what would you say?
You hit the nail on the head. I just think that make sure that it's not one person making this decision anywhere along the line, because what you don't want to wind up is presenting your idea and people publicly or at the 11th hour punching holes into it, having to send you back to the drawing board.
That's very good. Very true.
Collaborate with the appropriate people that are going to be impacted and have somebody leading the charge that will be the ultimate decision maker, but in a spirit of collaboration and as a caucus almost, to make sure that you're not making decisions in a vacuum.
I agree, completely agree.
Okay, excellent. So what we're going to move on to now is just some of the stay-at-home orders that have happened outside of New York and what impact these are going to have. Now, my understanding really is that it's not going to have too much impact. There's no new legislation. Catriona, you were mentioning that I think Colorado had brought in some additional sick leave days. Is that correct?
I believe Colorado introduced 4 sick leave days, but that potentially was before the federal bill was released. Okay. So now the federal bill would probably trump that because it is more. Correct me if I'm wrong, Jonathan or Raul. I can find that out and clarify, but I think that was before. So yeah, I think for most states, the federal bill appears to be the one that outside of New York that we follow.
Something I would advise people to do is go onto their computer and start Googling. You can have some really simple Google searches. So for instance, let's say that you are based or you have employees based in Arizona. Google Arizona sick leave law, or Google Arizona Department of Labor sick leave law, and you'll find out. And what you'll find out if you have employees all over, the states, as I understand it, and this could be updated, this is slightly old, states with paid sick leave include Arizona, California, Connecticut, Washington, D.C., Maryland, Massachusetts, Michigan, Nevada, New Jersey, Oregon, Rhode Island, Vermont, and Washington.
And Texas.
But it's really important to recognize that certain cities also have their own paid sick leave law, and those are a wee bit more hard to find. So you might need to go to a local HR person. Google it, obviously, everything starts with Google.
Yeah.
Google the name of your state and family medical leave, and absolutely Google the name of your state and Fair Labor Standards Act, because just like the family medical leave can have certain states can increase the relief provided there. States can also increase the amount of overtime payment employees should get, non-exempt employees should get. So you want to make all these Google searches. And if people want to contact me, I'll be happy to suggest some Google searches they can make on, because you can actually really get a decent outline in your own mind of what your general obligations are, which will make your discussions with a professional that much more productive. The more you can become educated before you start paying a lawyer hourly fees, fewer fees you're going to spend.
The only other thing that I would add to that is make sure that even if you think you know what your laws are, go back and double check them. New Jersey has changed them faster than I change socks on any given week. And you want to make sure that although you think you know what it is, go back and double check what you think you know, because there's some states that, and especially if you don't use these benefits often, and you feel that you're pretty liberal as you are, just double check yourself to make sure nothing has changed that would change your course of action. Yes.
Now there's a cultural, I don't know if this is going to be terribly helpful or not. There is a business cultural difference between the UK and the US. And a lot of your clients, Jeremy, are UK companies that are obviously have employees based in the US. In the UK, if you have an issue, a business issue, and you want somebody to bounce the issue off of, you tend to go to your accountant, not to your lawyer. In the US, if you have an issue, you tend to go to your lawyer, not your accountant, which is why we have the name counselor, which means something very different in the UK. Talk to both. I really would take the time to talk to both about whatever plans you have. If you have a business plan to release, to terminate some employees, whether there are additional state payments you have to think about, whether for either overtime or sick leave or family leave.
Got it.
And record all these, by the way, record them somewhere. Just document them, even if it's in your diary.
Perfect. So I would like to just ask you to get your crystal balls out for a second and try and think about what might be around the corner for some of these businesses. My understanding is that the initial stay-at-home order is lasting until this weekend. There perhaps will be a review at that point and perhaps a further stay-at-home order, or perhaps not. You know, there's a lot of uncertainty coming towards the weekend now, where are we in again for another 15 days, or are things going to change? You know, not going into all of the situation with coronavirus in America, but what can businesses be trying to do to anticipate, or just to, you know, prepare for what might be coming? And also, if you have any ideas on what might be coming, please do share.
On the morning following Election Day in 2016, I was doing a presentation at the Birmingham Airport for the British American Business Council about who just won the election, and we were all expecting a different outcome. And I was actually interviewed by ITV News, and they said, a lot of pundits are saying that because Donald Trump was elected, this, that, and the other thing was going to happen. And I'm not going to repeat what I said there, but I said, no, anybody who thinks that they can predict what's going to happen is wrong. They're simply wrong. There is no prediction. As far as I would go in this regard is you are going to have state approaches and you're going to have a federal approach, some kind of federal response. The federal response is wildly unpredictable at this point. They are talking about another law, another grant of a lot of money, which would be wonderful. But in terms of whether there's going to be a lockdown or a stay-at-home order past 15 days, you're going to have states saying one thing, the federal government saying the other, and even the states won't be united. So I think that we are in for a period of, I don't want to say chaos, but you're going to really have to pay attention to what's going on and understand that things are going to be extremely fluid for a while. Raul?
Yeah. My only other, exactly what you said, and absolutely not predictable. The only counsel that I would offer is make the decisions about your business thoroughly and slowly. Do not react, plan. Because to be reactive, you're going to find yourself swimming in uncharted waters, literally.
Yeah.
So be slow, be methodical, and make sure you're making a sound decision and not a decision based on the gut. The gut informs a lot of what we do, but it is not a good way to run a business. The president of the league, on the day that we were sent home about 10 days ago to work from home, said that what made her decide before it was mandatory to send us all is she wanted to act as if we had been exposed and make a decision how she would run the business if we had been exposed. Nobody had been in our office, but yeah, she wanted to make the decision because it allowed her to then pivot in any way that she wanted to go in after that. And that's really what you want to maintain, your flexibility and your agility to react as opposed to just, or to plan and make good choices as opposed to just simply making an impulse decision because we want to be open by Easter Sunday.
Yeah.
Easter Sunday's weeks away. We don't know what is going to happen. So to be planning that far ahead is literally using a crystal ball to decide what your business plan is.
Well,
my favorite, when people ask me how I make decisions, I always say the same thing. I measure twice and I cut once.
Raul, is it possible for, is it wise for a company to try to imagine what that company's own worst case scenario might be? Make sure that whatever plans they have include the resources, if possible, to withstand that, and that everything else beyond that is taken on a day-by-day basis without any long-term commitments being made.
Absolutely. Plan for the worst. Plan for the worst because that is what we should be doing. And that is exactly what got us into this pickle that we're in nationally and globally, that we didn't plan for the worst. And we're all reacting at the 11th hour. That's why we have no supplies. We have no ventilators because we weren't prepared for it. We didn't have a strategy. We didn't have a plan. We didn't think it through. Think of where you're going to be in the worst case scenario and then plan a roadmap on what are the steps that you need to take while getting there. So you're able to make decisions based on what's going on and you have a plan in place already, a plan that is fluid. No good plan is ever edged in stone, but a plan and at least a guidepost of where to go to next if things continue to get worse.
Right. I think we're going to basically draw the webinar to a close in a couple of minutes. I want to give one last opportunity for people to send in any questions now. If we see them before the webinar's closed, we will answer them. If they come in afterwards, we will put together a response and send those out. I'd just like to say a huge thank you to both Jonathan and Raul for giving their time freely to really benefit those who are listening on the webinar. I'd encourage you to get in touch with them if you are looking for any advice, obviously outside of the webinar. I'm sure they'd be happy to speak to you. They offer consulting services, and obviously Jonathan is a lawyer in the UK and the US. So please do get in touch. We will provide both of their contact details in a follow-up email. And yeah, we really look forward to working with you all through this period and seeing you all on the other side as well. So just one more thank you to Jonathan, Raul, and thank you to everyone for attending. Jonathan and Raul, I don't know if you had any closing remarks as well.
As for me, people are always afraid of hourly fees and things like that. Please call me up a question. I will not charge you unless I have told you that I will charge you. So please, if you have a question, there are companies preparing face masks and selling them at cost. There are people, 250,000 people today, individuals today in the UK volunteered to help those in need. And I think we all need to do our part. So I am not going to charge anybody who calls me for advice unless it gets to a point where I tell them. And even at that point, I'm going to be reducing my hourly fees just so we can get by this period. So please don't hesitate. Let's all be in this together.
Thanks, Jonathan.
Couldn't have said it better myself. I can sew a mask. I can make a ventilator. I can't make rubber gloves. I can't do anything for anyone except offer them some well-meaning advice based on the information that I have. And I'm happy to do that and help each other. You couldn't have said it better. I couldn't have said it better myself. Thank you, Jonathan.
Thank you. Thank you, everybody.
Great. Thank you so much, guys. We'll finish here. We will send out the recording, the questions, the contact details for Jonathan and Raul. And if you want another webinar like this, again, in a couple of weeks, if there are further changes, please just let us know. But thank you, everyone, for attending.
Thanks,
Thank you.
everyone.
Thank you.
Thank you all.
Thank you all.